This hearing starts off like it's going to be simple, and then it completely flips. A man comes into court facing drunk driving, no insurance, and reckless driving charges. He says he wants to represent himself. Then, almost right away, he tries to plead guilty to everything. That sounds quick and easy, until the judge starts asking basic questions and realizes this case is not as clean as it looks. That's where this gets good, because this isn't just about what happened on the road. It's about whether this defendant even understands what he's doing in court. He says one thing, the test results suggest another, and the judge can see this is heading toward a legal mess. What looks like a fast guilty plea starts turning into a warning sign, and once the court digs into the facts, the whole thing begins to wobble. Then the docket keeps moving. You've got a second defendant dealing with retail fraud, bond arguments, and a court trying to figure out whether this is a one-off mistake or part of a pattern. After that, it shifts again into something a lot more real and a lot less flashy. Missed payments, missed hearings, no address, no income, and the kind of everyday court struggles people don't talk about enough. So stay with this one, because the biggest moment here is not someone getting found guilty. It's a judge stepping in and saying, no, I can't accept this. And honestly, that says a lot about how a courtroom is supposed to work. Let me know in the comments. If someone tries to plead guilty that fast, do you see honesty or a guy walking straight into trouble?
Good afternoon, person at the jail. Please state your name for the record.
Christian Parks.
This is case number 261378 SD. We're here for an arraignment. Sir, you met with somebody from Community Corrections and gave them some contact information. Was that information accurate?
The stuff that I gave the person just now? Yeah, yes.
Your address and phone number, all that was accurate?
Yep, 1490 Helena. I can give you the phone number again if you want to. 947.
I've got it. Ends in 7608.
Yep.
All right. And did you have the opportunity to meet with somebody from the defender's office today?
Yeah.
I have a complaint that alleges that on or about April 18th, 2026, in the township of Antioch in Wexford County, it is alleged in count number 1 that you committed the offense of operating while intoxicated. That is a misdemeanor punishable by up to 93 days in jail and or a fine of $100 to $500 and or 360 hours of community service, rehabilitative programs, vehicle mobilization mandatory with a prior, and reimbursements for cost of governmental expenses and prosecution. In count number 2, it's alleged that you committed the offense of operating a motor vehicle without security or insurance. That is a misdemeanor punishable by up to 1 year in jail and or a fine of not less than $200 nor more than $500. In count number 3, it's alleged that you committed the offense of reckless driving. That is a misdemeanor punishable by up to 93 days in jail and or a fine of $500. Do you understand those charges and the potential penalties?
Sure.
Did you read and sign an advice of rights form at the jail? Talk about your rights to an attorney and your rights to a trial?
Were they given to me?
Well, that's what I'm asking. Did you
Yes,
sign
yes.
that? Did you read and
Yeah.
sign that form?
I think that's what I have here, yeah.
It was given to you earlier, you read it, you signed it, and you handed it back to the office.
Yeah, I did.
Did you understand those rights?
Yes, sir.
You do have the right to be represented by an attorney at all phases throughout this process. And if you cannot afford one will be appointed to represent you at public expense, but you may be required to repay a portion of that expense. Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
Just gonna represent myself.
Here's the first red flag. He wants to represent himself. Yes, that's his right. But this is exactly why judges slow things down when someone says that. The court has to make sure he understands what he's giving up, because once he waives a lawyer, he doesn't get special treatment. He's expected to follow the same rules as the prosecutor, know the same process, and protect his own rights. That's a dangerous game, especially in a criminal case with multiple charges. And the judge knows it. That long warning isn't just courtroom routine, it's the court making sure this doesn't turn into a disaster later. Because once a defendant says, "I'll do this myself," the court wants it crystal clear that he knew the risks. And from the way this is starting, you can already feel this might not end well.
So before we can do that, I have to make sure that that's a accurate waiver. So give me just a second. There's a form I need to fill out. So how many years of education do you have?
I finished high school.
All right. All right, so this form says, "I am the defendant in this case. The judge has explained to me, and I understand that I have been accused of a crime, and I have read or have had read to me the charges against me, and know the minimum and maximum possible sentences, the nature of the charges, and that there may be lesser included offenses, defenses, or mitigating circumstances. That I had the right to be represented by a lawyer at all stages of this process, and that the court will appoint one for me at public expense if I cannot afford one. That I had the right to consult with a lawyer that I hire or that the court appoints. That I have the right to act as my own lawyer. That if I represent myself, I will be held to the same standards of law and procedure as a lawyer and will not get any special treatment from the court. The risks of being my own lawyer, including that a lawyer has skills and expertise that I do not in preparing for and conducting a criminal defense and trial, and that the state does have an experienced lawyer. Unlike the prosecutor in this case, I will be exposed to the dangers and disadvantages of not knowing the complexities of jury selection, procedure, or how to preserve my appeal rights. That because of these things, it can be unwise to act as my own lawyer. I knowingly and freely waive my right to the assistance of an attorney and choose to represent myself. I do not want to hire an attorney or have the court appoint one for me. I have no doubt about my decision, and I have 12 years of education. I read and understand the English language, and I am mentally sound. Mr. Parks, having gone through that, do you still wish to continue to represent yourself?
Yes, sir.
All right. If at any point you decide that you want the court to make a referral to the public defender's office, all you need to do is let us know that, and we'll make that referral. And that's something we'll go over each time that we have you in court. So today you have a couple options available to you. One is to plead guilty. If you pled guilty, all 3 misdemeanors would enter on your record, and we would not be able to sentence today because it is required that you have a substance use assessment completed. If you pled not guilty, we would set the matter for a pretrial, which would then give you the opportunity to discuss the case with the prosecutor and see if there's a way to resolve it other than guilty pleas or going to trial. Do you understand those 2 options?
Yep.
And then he does it. He pleads guilty right away. That's the kind of moment that makes you think the hearing is about to be over in 5 minutes. But a guilty plea isn't just a yes or no answer. The judge still has to make sure it's voluntary, informed, and backed by actual facts. The court can't just take "I'm guilty" and move on. That's why the judge starts locking everything down. No threats, no promises, no pressure. Your choice, your decision. It may sound repetitive, but this is the legal foundation. If this plea falls apart later, the court record matters. And with this defendant already going without a lawyer, every answer counts even more. He may think he's making this easier, but right now, he may actually be making it worse.
Then how do you plead today? Guilty or not guilty?
I am guilty.
All right. Will you please raise your right hand? You solemnly swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth.
I got it.
All right, you may put your hand down. Has anybody promised you anything in order to get you to plead today?
Nope.
Has anybody threatened you in any way?
No, sir.
And is it your own free choice to plead today?
Yes, it is.
Back on April 18th, were you on probation or parole?
No.
Were you on bond in any other file?
And any other what?
In any other file?
I don't think so.
Were you under the supervision of any court?
No.
All right. I know we just went through your rights with you. Do you have any questions about those rights? Or I'm sorry, we discussed those rights. Do you have any questions for me about them?
No, I don't think so.
Well, now's your chance. So do you or don't you?
No.
Most importantly, do you understand that you have the right to have a jury trial and that by entering a guilty plea today, you'll be giving up that right and you won't have a trial of any kind?
Yeah.
Your Honor, I don't know if this would be appropriate, but just to make sure he protects his rights, he is looking tired and maybe intoxicated still. Has he been tested?
Do we know what his level was at the time of his arrest, Ms. Doe?
0.14, 0.15.
This happened 2 days ago, so I think he's sober.
All right.
But thank you for that, Mr. Hartel. Ms. Doe, are you aware of any promises, threats, or inducements not made part of the record?
I'm not.
Then Mr. Parks, to the allegation then that on or about April 18th, 2026 in Antioch Township of Wexford County, how do you plead to count number 1 of operating while intoxicated?
Guilty.
And to count number 2 of operating a motor vehicle without security? How do you plead?
Guilty.
And to count number 3 of reckless driving, how do you plead?
I guess due to the first one, that's guilty.
In order to accept those guilty pleas, I must have you tell me what it is that makes you guilty. So back on April 18th, were you operating a motor vehicle in Antioch Township of Wexford County?
Yep. Yes.
And prior to operating that motor vehicle, had you consumed alcohol?
It was in my system.
Or was it in your system because you consumed it?
That's the only way it gets there, so, yeah.
How much had you had to drink?
There's just a couple beers. Those just a couple beers.
Ms. Dahl, what did you say the intox leisure was?
157.145.
So, Mr.
This is a big moment. Someone in court points out that the defendant looks tired and maybe even still intoxicated. That matters a lot, because if someone is impaired while trying to plead guilty, the court has to be extremely careful. A guilty plea has to be knowing and voluntary. If the defendant isn't fully clear-headed, that becomes a real legal problem. Then the alcohol level gets mentioned, and now this isn't just a feeling. There's a hard number tied to the case, so the judge has to slow down even more. This is the court protecting the process and protecting the defendant at the same time. And honestly, that's smart. If you're a judge and something feels off, you don't rush. You make sure the record is solid before you let someone plead away their rights.
Parks, the prosecutor says that when they did your breath test back at the jail, you blew a .157 and a .145. Do you stipulate or agree to using those results for purposes of the plea?
I mean, yeah.
All right. Do you have any reason to doubt those results?
Nope.
Was that a no? I couldn't hear you. I need you to answer me. I
Nope.
can't accept a
Nope. No.
Then to count number 2, that you operated a 2012 Ford F-150 without insurance. Were you the owner of that vehicle?
Yes.
And did you know that it didn't have insurance?
Yes, I believe it was that Friday that my insurance, they had just sent me a letter saying that it wasn't gonna work anymore. What was it? Something got deferred, and so I wasn't getting paid until the upcoming week, so.
So that
No,
the
I
letter
didn't
you
have
received,
insurance. I had no insurance. It was from Bristol West.
was from what? I'm sorry.
Bristol West, the insurance company.
All right, but you knew that they had canceled your insurance.
Yep.
And then to count number 3 of reckless driving, what did you do that made you a reckless driver?
Probably operating while intoxicated would make me a reckless driver.
Do you know what you did?
Crash my truck.
How? So do you have any memory of how you were driving before you wrecked your truck?
So on a straightaway, rear wheels kicked out. It was raining. When I came off the road, and by then I was closing my eyes because I realized I was gonna go off the road. So
You realized what?
I was going off the road.
Now, did you say your wheels kicked out?
Rear wheels lost traction.
Do you know how fast you were going at the time?
I was probably going at least 5 over. It was like 65.
How? Did law enforcement see you driving?
No. From what I have been told, there was a call, and then they called people afterwards.
You were written a civil infraction or a ticket for defective tires. What were your tires like?
Defective. I mean, they were just bald, not like slick bald, but below your dye mark that you're supposed to have on them.
And here it is, the turning point. The judge says he can't accept the plea. That's huge. A lot of people think once a defendant says guilty, that's it. Case closed. Not true. The judge still needs enough facts on the record to support each charge. And here, he's not getting that, especially on the reckless driving count. So instead of forcing it through, the judge stops it. That's not the court being difficult. That's the court doing it right. And honestly, this is also the clearest example yet of why self-representation can go sideways. A lawyer would know how to lay out the facts in a way that matches the legal elements. The defendant clearly doesn't, so what looked like a fast guilty plea has now turned into a full reset.
All right, Mr. Parks, there's certain ways in which the court can accept a plea based on factual basis, and from what I'm hearing right now, I don't have enough to accept a plea to all of the charges, and that's nothing that you've done or nothing that you've said or not said. It's just based on what you've told me so far. I can't accept the plea, especially to count number 3. So what is going to happen next is I'm going to have to set the matter for a pretrial. So I'm going to enter not guilty pleas. I'm going to set the matter for a pretrial. And that will give you the opportunity to discuss the issues with the prosecutor and see if there's see if the case gets presented to me differently, or if there's a plea agreement that can be worked out. But based on what you've told me, I can't find you guilty of all the charges. So knowing that, do you still wish to continue to represent yourself, or do you want the court to make a referral for an appointment of an attorney?
Is there any negative possibility, any negative things to me doing that? Or just the possibility of a conversation at that point, right?
Well, if they take the appointment, if you meet the requirements for indigent defense, they would represent you in court. You might get charged an attorney fee. Usually, if I do order those, it's $150 or less. And a lot of the times the public defenders will waive them. So I don't know what will happen in this case because I can't make that prejudgment. But that's a potential outcome that you could have. Obviously, an attorney would be able to walk you through the process. They would be able to review the evidence, see whether or not whether or not you have any type of defense to any of the charges you have, and perhaps even be able to negotiate a different plea agreement.
And just like that, he asks for a public defender, probably the smartest move he's made all day. The judge explains it simply: a lawyer can look at the evidence, check for defenses, guide him through the process, and possibly work out a better resolution. That's the difference between trying to survive court and actually navigating it. He also explains that if a fee is ordered, it's usually limited. So the defendant is finally seeing that asking for counsel may cost a little, but going without one may cost a lot more. Then the hearing shifts to bond, and the judge does something important. He cuts the defendant off before he starts saying too much about the case. That's the court protecting his right to remain silent, even when he doesn't seem ready to protect it himself.
Well, I guess why not? Let's do that shit. Yeah.
All right, so we will make a referral to the public defender's office for the appointment of an attorney. I'm going to enter a not guilty plea, and we'll set the matter for that pretrial that we talked about. Now that gets us to bond, and bond is based upon the risk that you pose to society and the likelihood of you appearing at future court appointments. Where is Heartland at? I'm not familiar with that town.
I believe it's Livingston County, right outside of Oakland County. It's like right here. It's about 3.5 hours southwest. I have family up here, and I was coming to visit Tibby Dam for the weekend, so I had no live up here. And then,
all right. So I don't want you to say anything else about the case because you've got the right to remain silent. So, is there anything that would stop you from coming back to court?
No, I actually have court up here soon.
All right. Counsel, I do not show any prior history for Mr. Parks, and the praxis scores him at a risk level 2. But I don't know how I do know how he's scoring that way. So one is his length of residence. He hasn't been at that residence for a year. But Mr. Parks, you self-reported, it looks like, or somehow community corrections have you down for having a prior conviction. Have you been criminally convicted somewhere before?
Criminally convicted?
Yeah, so I see some driving offenses, but actually an actual conviction for a crime, I don't see any. So have you been?
I got a public intoxication in Texas once.
Okay.
If that's what the criminal thing is, that's the only thing I can think of. Other than that, that's all.
All right, so that's not showing in our records. Not knowing whether that's been expunged or whether or not there was truly a conviction, is there any objection to rescoring down to a 1 on this, Ms. Dull? Mr. Hartel?
Oh, I would never object to going down.
All right, so we will change history or the praxis to a risk level 1. Any comment regarding bond, Mr. Hartel?
Yes, thank you, Your Honor. Not only is that a low practice score with possibly a misdemeanor, but his family is here for moral support. I believe father and grandfather, if I recall correctly. I did speak with them briefly before court. I know they were going to encourage him to use a public defender if he didn't use one today, although he might have been less for us to do if the plea had gone through, I'll put it that way. But what I would ask the court to do is grant a personal recognizance bond. I believe that's appropriate. He does have strong ties, at least to the state of Michigan, at least some ties to our local community. And even if he does spend the time down there in Heartland, I'm sure they could set up random testing, things of that nature. I don't doubt the court is going to require some level of testing. I didn't get this much detail with him when I was meeting with him earlier, but I would encourage him to consider the daily testing machine. I believe that might be easier for him. But again, I don't know if the court's going to require random or daily, but I do believe either way, a PR bond is appropriate, especially with the amount of support his father and grandfather have noted that they will be placing. I don't want to put too much burden on them and say they're going to be babysitting, but they're definitely going to be following up with them. I'll phrase it that way. Thank you.
Thank you. Ms. Dahl?
This bond ruling is pretty balanced. Defense says he has family support, ties to Michigan, and a low-risk score. The prosecutor focuses on public safety, the alcohol level, the crash, and even that prior public intoxication incident out of Texas. So one side is saying he'll show up, the other side is saying he still needs structure. The judge lands in the middle. He gives him a personal recognizance bond, meaning he can be released on his promise to return. But there are conditions. No alcohol, random testing, no illegal drugs, and not even recreational marijuana. That tells you exactly what the court is worried about here. Not just whether he comes back, but whether his behavior stays under control while the case is pending.
Your Honor, the people's concern in this situation is the safety of the community. Due to the level of intoxication, also in the police report states that he tried to pass on the shoulder and then eventually ended up losing control and crashing his truck that was upside down into the trees. So a very serious accident. So I would ask the court to do either daily testing or random alcohol testing, also because he self-reported that he has a public intoxication conviction in other states. So it seems like alcohol has been an issue for him. Thank you.
All right, Mr. Parks, I am going to release you on your personal recognizance, which is your promise to come back to court with some conditions. That you appear as ordered, keep your contact information current, not leave the state without permission, and to commit no new crimes. I am going to order that you not consume any alcohol, and you'll be subject to random testing. If you want to take the daily machine home with you, that's an option you have, but I'm not ordering that. It is $10 a day to have that machine though, just so you're aware. I'm also going to order no illegal controlled substances, including recreational marijuana, and you'll be subject to random testing for that as well. I believe those bond conditions are appropriate to help protect society. Given the level of intoxication in this case that was discovered during the plea taking process, 0.157 and a 0.145. Also based on the self-reported public intoxication out of Texas, even though I didn't score it, it still does cause the court some concern. And I believe the no controlled substance, including recreational marijuana, is appropriate because I don't want one substance traded for another. So, Mr. Parks, at some point, you're going to be released from the jail today. You'll need to come over here to the courthouse, which is about 5 blocks from where you're at. Go to the community corrections office and get signed up for your testing requirements, and then they can discuss with you what options you have and how testing works. Before you leave the courthouse today, you'll have your next court date, so make sure you keep that court date, and then you should be hearing from the public defender's office within a couple of days. Do you have any questions for me about your bond conditions?
No. Why would I want to have that daily testing machine? Is there positives to that?
Well, one of the positives is that you wouldn't have to call in every day and try to find a testing facility to test you. You'd be given certain times that you would have to blow on the machine, and then that would be your alcohol test. So that's one advantage, but I'm not ordering it, but that's an option you have as opposed to doing the random alcohol testings. You'll still have to do the random drug tests. Those will still be random.
Okay.
All right.
Understood. Yep.
All right. Thank you. Thank you.
Now the docket shifts to a completely different defendant and a completely different kind of problem, retail fraud. And this is where you really see how court works in layers. The charge changes, the facts change, but the system stays the same. Rights are explained, bond gets discussed, counsel gets addressed. That structure matters because every person coming through court is supposed to get the same legal foundation, even if their situation looks very different from the last case. What stands out here is how direct this defendant is. He doesn't try to play lawyer. He doesn't try to explain too much. He just says he needs a public defender. Honestly, compared to the first case, that may end up helping him a lot more than trying to wing it.
Jail, I think we've got one more there.
Yes, Your Honor, just one moment.
Good afternoon, person at the jail. Could you please state your name for the record?
Cody Petrie.
This is case number 26139SM, the people of the state of Michigan versus Cody Petrie. We're here for an arraignment. Mr. Petrie, did you have the opportunity to meet with somebody from the defender's office today regarding this new case?
Yes, Your Honor.
I have a complaint that alleges that on or about March 18th, 2026, in Herring Township of Wexford County, it is alleged in count number 1 that you committed the offense of retail fraud 2nd degree while at Walmart. That is a misdemeanor punishable by up to 1 year in jail and or a fine of $2,000 or 3 times the value of the property taken, assuming the prosecutor can meet certain requirements. Do you understand those charges and the potential penalties?
Yes, Your Honor.
Did they give you another advice of rights form to fill out at the jail for this file?
I think so. I don't know, but I don't know.
All right, so I'm going to go through your rights with you just to make sure we've covered them on the record. If you require accommodations to use the court because of disabilities, or if you require a foreign language interpreter to help you fully participate in court proceedings, please contact the court immediately to make arrangements. You've been brought to court on a misdemeanor charge and you have the following basic rights: to plead guilty or not guilty, or to stand mute. If you stand mute, a plea of not guilty will be entered and you may plead no contest with the permission of the court. To have a trial by jury and to have the assistance of an attorney. You have the right to an attorney appointed at public expense if you are indigent, which means without money to hire an attorney, and if the offense charge requires a minimum jail sentence or the court determines that it might sentence you to jail, the appointing authority will decide if you are indigent and appoint counsel if you are eligible. You may have to repay the expense of an appointed attorney. You may contest your ability to pay the ordered fees if the court attempts to collect any costs for an attorney, and the court must determine your ability to pay at that time. If you have a trial, you have the following rights: to call witnesses to speak for you at trial. You may get an order signed by the court to require witnesses to come to court, to see, hear, and question all witnesses called against you, to be a witness for yourself or to remain silent. If you choose to remain silent, that silence cannot be used against you. Also, the right to be presumed innocent unless proven guilty beyond a reasonable doubt. If you plead guilty or no contest and your plea is accepted, you will not have a trial of any kind and you'll be giving up those trial rights that we just went through. You also have the right to be released on bond, and we'll get to that in a moment. If you are now on probation or parole and you enter a plea of guilty or no contest, or a finding of guilt is made by a judge or jury, it may result in a violation of your probation or parole. You can be sentenced to jail and fines plus costs. The court will tell you on the record the name of the offense, the mandatory minimum jail sentence, if any, and the maximum possible penalty for the offense, including jail, fines, or both. Fines, costs, and other financial obligations imposed by the court must be paid at the time of the assessment, except when the court allows otherwise for good cause shown. If you are not able to pay due to financial hardship, please contact the court immediately to request a payment alternative. An appeal to the circuit court may be taken within 21 days from the date of sentence or is permitted pursuant to court rule. If the sentence includes incarceration, and if you wish to file an appeal but are financially unable to retain a lawyer to assist you, the court will appoint a lawyer to represent you on appeal if the request for the lawyer is made within 14 days from sentencing. Federal law and or state law may prohibit you from possessing or purchasing ammunition or a firearm, including a rifle, pistol, or revolver. If you are convicted of a misdemeanor crime of violence and you are a current or former spouse, parent, or guardian of the victim, you share a child in common with the victim. You are or were cohabitating with the victim as a spouse, parent, or guardian, or you are or were involved with the victim in another similar relationship. Mr. Petrie, do you understand those rights?
Yes, Your Honor.
You do have the right to be represented by an attorney, and if you cannot afford one will be appointed to represent you, but you may be required to repay a portion of that expense. Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
I need a public defender. I need one assigned to me.
Court will make a referral to the public defender's office for the appointment of the attorney. We'll enter the not guilty plea, and we'll set the matter for a pretrial. That's where your attorney and the prosecutor will get together to see if there's a way to resolve the case short of going to trial. You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. There was not a praxis done in this matter. Ms. Pirvento, any comment regarding bond?
Thank you, Your Honor. It's my understanding that Mr. Petrie is being held on another file that has a hearing scheduled for Monday. In light of that, we would just respect the request, a low cash bond. Thank you.
Thank you, Ms. Lawrence.
This bond argument is really about one question. Is this a small theft case, or is it part of a bigger pattern? Defense wants a low bond. The prosecutor points out this appears to be another retail fraud case in a short time, and says Community Corrections had trouble staying in contact with him before. That changes how the court sees risk. It's not just about the charge itself. It's about whether the defendant has shown he'll follow the rules. The judge works through the record, clears up what other case he's sitting on, and then sets a $500 10% bond with a no contact order for Walmart. So no, this isn't the harshest ruling in the world, but it is the court saying, we've seen enough here to take this seriously.
As you know, this is the defendant's second retail fraud in less than a year, I think it was less than 6 months within each other. So I do think a monetary bond would be appropriate. If I recall correctly, I think Community Corrections had a difficult time staying in contact with him on his last file. So I do think a monetary bond would be appropriate, and I would also ask for a no contact order with Walmart.
Thank you. Somebody refresh my memory. Mr. Petrie is sitting pre-trial on a matter, correct?
I think he was recently sentenced last week.
He was sentenced by us.
He was sentenced last week.
And then it says he's hearing on Mondays for a probation violation.
Here or with
Upstairs.
circuit? With circuit. All right.
But he
So-
was sentenced-
Is he on a remand then with circuit?
The file that we have is for a probation violation, and we have a remand. And when I was looking at Mr. Hartel's file, but Mr. Hartel is on that case.
Okay,
We sentenced him on the 8th for 15 days with 2 days credit.
so he's still under sentence then.
Well, with good time, probably close to being.
All right, the court is going to set a monetary bond. I'm going to do a $500 10% bond. Mr. Petrie, you are to appear as ordered, keep your contact information current, not leave the state without permission, and commit no new crimes. Also, you're not to have any contact with Walmart. That includes the main store, being on the property, or at the gas station. All right? Anything else for the record, counsel?
No, thank you.
No, no, thank you.
All right, thank you. Thank you, Mr. Petrie. Thank you, jail.
Thank you.
And that completes the docket. Sir, you're here on a bench warrant for fail to appear for a financial review hearing. Set for financial review hearing back on October 30th. I see a bond was posted, which we currently owe the court $362.60. I see a $363 bond was posted, but that wasn't posted. Was that posted by you?
No, my stepbrother posted it.
All right. So,
Did have a payment just plan set up.
uh-huh.
For some reason, when I called up here, they put it on a different fine. Just to pay it.
All right.
You know what fine I'm putting it on? I haven't changed it, so. It's the same one every month.
Do you have, so it looks like there's 2 cases we have here. Do you have cases in the other
Well,
courts?
I don't make sense.
Okay,
They tried saying they don't have record from me bonding out last time when I called up here. That's another issue that I'm dealing with, so. They said that I haven't been here, and I'll go for it.
all right. Well, do you want to get set back up on one of those
Yes, sir.
payment plan again?
Yeah.
How much can you do a month?
Let's keep the same plan I had, just do the
25? When can you make that first payment?
I'll be back. I can do it today.
And then do you want to do like the first of the month, last of the month? What works better for you?
Or whatever, first, yeah.
All right.
I'm pretty sure you remember last time, though.
I know we were back here in, looks like April. Yep. And then we set it for financial review hearing in the 3 months and that's the one you missed. So we're gonna go ahead and we'll reset it again for another financial review hearing. So you'll get that one, you'll get
These last two cases are quieter, but they matter just as much. Now the issue isn't drunk driving or retail fraud, it's money, missed payments, missed court, confusion over fines, no address, no income. This is the part of the court system a lot of people never see, but it's real for a lot of defendants. Sometimes the problem isn't refusal, it's instability, and the judge handles both matters in a pretty practical way. In one case, he resets the payment plan and gives the defendant another chance to show good faith. In the other, he hears that the man has no income and no contact information, and instead of hammering him, he releases him on personal recognizance and pushes the review out 3 months. That tells you the court is trying to separate can't pay from won't pay.
next court date at the window. So I'll need you to go out there and get that, and then you can make that payment. And like I said last time, as long as you're showing good faith, I'll work with you on that. Okay?
Yep.
Thank you. Person at the jail, please state your name for the record.
James Simons.
All right, Mr. Simons, I'm Judge Wiggins with the 84th District Court. You're here on a bench warrant for fail to appear at a financial review hearing back in March. I see Community Corrections spoke with you this morning, and you don't have a mailing address or phone number, is that correct?
Not at the time.
All right. I show that you currently owe the court $310. I assume you can't make a payment on that today?
No.
Are you able to commit to any type of monthly payment at all?
I don't even have an income. I don't even have an income coming in at this time.
All right. So what I'm going to do is I'm going to release you from the jail on your on a PR, and we're going to reset this for another review hearing in 3 months. So you'll have that next court date before you leave the jail today. If you're able to start making a payment, that's great. Go ahead and do that. But if not, we'll see you back here in 3 months, and we'll discuss your finances at that time again. All right.
All right.
All right. Thank you. Thank you, jail.
Thank you, Your Honor.
And that's it for today. You're adjourned.
This docket covered a lot, but the message was pretty clear. In the first case, a man tried to plead guilty to drunk driving, no insurance, and reckless driving, but the judge refused to accept a plea that wasn't fully supported by the facts. He got a public defender, a not guilty plea was entered, and he was released with strict testing conditions. In the second case, a retail fraud defendant got appointed counsel, a pretrial date, and a cash bond with a no contact order. And in the final cases, the court dealt with missed financial reviews by focusing on payment plans, PR release, and whether people actually had the means to comply. That's what stood out here. The judge didn't treat every case the same. He looked at the facts, the risk, and the person in front of him. If you found this case as wild as we did, hit like. Drop your thoughts in the comments, share this with somebody who loves courtroom breakdowns, and don't forget to subscribe for more.